In this lesson, we're going to break down the land sale contract, the merger doctrine, marketable title, duties imposed on the seller, and ultimately equitable conversion and risk of loss. Or in other words, we're going to focus on the contract stage of the purchase and sale process of real property, right? Which is a great place for us to start. It's important to recognize anytime we're thinking about the process of the purchase and sale of real property, we should recognize that there's two distinct stages, right? We have the contract stage and the deed stage. The contract stage is everything leading up to closing, right? And from this point forward, when I use the word closing, what I'm talking about is the transfer of ownership in the property from the seller to the buyer, right? Essentially, when the deed is delivered from the seller to the buyer and we have transfer of ownership from the seller to the buyer, that's what we mean by closing, right? So the contract stage focuses on everything from the negotiations to the formation of the contract to the execution of the contract, all the way up until closing, right? And at closing, when ownership of the property is transferred from the seller to the buyer, we get merger, right? And the doctrine of merger tells us that the contract actually merges into the deed. So any liability past merger must be based on the deed, right? All liability leading up to closing has to be based on the contract, right? Provisions in the contract and our contract principles we're going to go through during this lesson, right? So pre-merger, right? Liability has to be based on the contract. Post-merger, contract merges into the deed. All liability must be based on the deed. So very important to recognize. If there's a provision in the contract that is not included in the deed, right, and we're after merger, right, the party cannot enforce that contract provision that's not in the deed after merger. It's a very commonly tested fact pattern, right? So if there's some provision in the contract that's not included in the deed, once we get past merger, that's tough luck. The contract's now off the table. All liability must be based on the deed after closing, right? And remember, closing is when the ownership of the property is transferred from the seller to the buyer. After that point, contract merges into the deed. All liability must be based on the deed from that point moving forward. Okay, but today in this lesson, we're going to focus on the contract stage, right? Everything leading up to closing, right? The negotiation process, the contract formation process, the execution of the contract, everything that goes up to maybe inspection of the property, everything that leads up to actual closing, delivery of the deed, right? Where we see that ownership transfer in the property from the seller to the buyer, right? We're gonna focus though on the contract stage, right? So the first thing we have to recognize is how a valid contract for the sale of land is formed, right? And our starting point rule is that a contract for the sale of land must satisfy the statute of frauds. We probably all know what this means by now, but generally this means that it must be in writing and signed by the party against whom enforcement is sought, and contain all essential terms of the deal, which is usually the parties, the property description, the price. You probably also want to see a manifestation of intent to actually sell the property, right? But as long as it's in writing, signed by the party against whom enforcement is sought, and contains all essential terms of the deal, it's going to satisfy the statute of frauds. It's usually pretty straightforward. Our main exceptions, part performance and detrimental reliance, our main exceptions to the statute of frauds apply here. And we do have a lesson, right? Because statute of frauds is more of a contract law analysis. In this lesson, I want to focus more on the property aspects of the analysis, and we do cover, right, the statute of frauds as it's applied to real estate contracts in a lot of detail in our contract law module. So I'll put a link below if you want to refresh yourself on the statute of frauds applied to the real estate contract. But just to remind everyone, the big picture exceptions, remember part performance, if any two of the following three are satisfied in most jurisdictions, that'll be a valid exception to the writing requirement of the statute of frauds. We would say if the purchaser takes possession, if the purchaser makes payment, or the purchaser makes substantial improvements on the property, right? If any two of those three are met in most jurisdictions, right, that's a valid exception to the writing requirement. Remember, because we're saying, hey, look, if the purchaser took possession, made payment, and then started improving the land, that's really strong evidence that a contract must have existed. Even if we don't see one in writing, all of that performance shows us it's likely a contract did exist. And of course, we always have detrimental reliance as an exception to the statute of frauds. So if there was an oral promise to sell the land and the buyer reasonably and foreseeably relied on that promise to his detriment, right, that could always be an exception to the writing requirement of the statute of frauds. But again, all of that's broken down in way more detail in our actual contracts lectures on the statute of frauds. So make sure we'll put a link below that you check that out if you want a refresher on how the statute of frauds is applied to real estate contracts. But important to recognize, I don't think you would see that tested very often in an actual real property exam as much as it would come up in contracts fact patterns, right? If you see the statute of frauds being tested, it's probably more so in the context of a contracts fact pattern. What we're going to see in the contract stage, usually in real property, is marketable title, right? Duties of the seller, equitable conversion, which we can jump right into marketable title. Right, so we say as our starting point rule here, all land sale contracts require the seller to deliver marketable title to the buyer at closing. So before we jump into what marketable title is, I think it helps sometimes to frame what a purchase of real property actually is, right? If we look at it through this context, I think it helps us really see what marketable title is all about, right? So if we think about what we're actually purchasing, right? Say you have saved up millions of dollars, right? You move on past Studicata, you get past the bar exam, right? And you make millions of dollars as a big shot attorney. So you want to go buy a really expensive mansion to live in. So you're going to go spend millions of dollars on some sprawling mansion, right? Well, when you're buying that mansion, are you really buying the mansion? Are you buying the house? Arguably, but kind of not really, right? Are you buying the dirt that the mansion is on? Not really, right? You could remove the dirt, you could bulldoze the mansion. That's not necessarily what you're purchasing, right? It's included in your purchase, or you get the mansion, you get the dirt, the soil, but it's not necessarily what you're actually purchasing, right? Because you could just bulldoze all of that stuff, right? What you're actually purchasing is title to the property, right? You're purchasing a little certificate that says you own this, you hold title to this land, right? You're not purchasing the land itself necessarily. You're not really purchasing the dirt that the house sits on. What you're purchasing is a title, right? You're purchasing certificate, a little piece of paper that says you hold title to this land, right? And we know once you hold title, that gives you a bundle of rights, and that's really what you're purchasing. You're purchasing title that gives you a bundle of rights, things like the right to use and enjoy the land, to sell the land, all kinds of rights that come with holding title. But when you think about it like that, essentially what you're doing in that scenario is you're paying millions of dollars potentially for a little piece of paper that says you hold title to this land. Right, so inherently, that carries a lot of risk with it when you think about it. What if there's a problem with the title, right? Either this person doesn't have the title, the seller thinks they have title but they don't, and you ended up just spending millions of dollars on title that didn't exist in this person to begin with, or there's a problem, there's a defect with the title, right? There's a lot of risk there if you're spending millions of dollars for a little certificate that says you have now rightful title to this land, right? So what marketable title basically ensures is that at closing, right, we require the seller to deliver marketable title to the buyer, right? And this really requires that the title is free from an unreasonable risk of litigation, right? So basically, the rule is going to be all land sale contracts require the seller to deliver marketable title to the buyer at closing. If the contract is silent about the quality of title that the seller must deliver, the law requires marketable title. So there's no way around it, right? You have to deliver marketable title. Right now, you can write your own express provisions about the quality of title, which we'll talk about in a minute. Maybe if there's a problem with the title, of course, you can always disclose that, and a purchaser can choose to buy whatever title you disclose, but it has to be disclosed. If you fail to disclose, right, the law is going to require that the seller does deliver marketable title, right? And marketable title is title that is free from an unreasonable risk of litigation. Now, if you look out there, there's going to be all kinds of definitions as to exactly how to define what marketable title is, right? My favorite definition, because it's easy to remember, is marketable title is title that is free from an unreasonable risk of litigation. It's just one of these terms that's kind of hard to define, and courts really split on the exact language to use, but you should be good if you use this definition. Marketable title is title that is free from an unreasonable risk of litigation, right? But sometimes it's better that rather than trying to define what marketable title is, it's better to think about what marketable title is not, right? What we want to look out for on a real property fact pattern, that would be the seller not delivering marketable title, or where the seller is delivering unmarketable title. And we have two major situations to look out for, right? Title is not marketable if the seller does not own the estate he purports to be selling, or the seller's title is subject to an unapparent encumbrance. Right, so let's break down this first one. A seller does not own the estate he purports to be selling. This is classic, right? The major two you would see is the seller has a life estate and is trying to convey fee simple to a buyer. Right? We know a seller who has a life estate cannot convey a larger interest in the property than what he holds, right? So if a seller, maybe he thinks, right, it doesn't matter, beknownst or unbeknownst to the seller is trying to convey fee simple, but the seller only has a life estate, right? That's a big problem. It could turn out later, oh, if he's only got a life estate, we know when he dies, the property goes back to whoever granted the property to him, right, to the original grantor. So if this person now transfers, right, if you buy title that's got this reversion floating on it and you didn't know about that, or again, think about the mansion example. You spend millions of dollars to buy title, but this person didn't really have the title you thought he did, right? You thought you were getting fee simple, but really it was a life estate. Well, that's going to be pretty unfortunate, right, if that can transfer back to the original grantor, right, whoever conveyed the life estate to the seller, right? So if the seller does not own the estate he purports to be selling, this would also be like co-tenants. Say someone has a 50% share in Greenacre and fee simple, and they try to sell you the entire estate. They try to sell you a 100% share in Greenacre, right? Well, that would be another example where the seller does not own the estate he purports to be selling, right? If someone says, hey, look, I'm giving you title to 100% of Greenacre and fee simple absolute, but they only hold 50%, right? That's going to be a problem, right? Title is not being delivered marketable at that point. We'd say that title is unmarketable. Right. The other thing we want to look out for is encumbrances, right? Where the seller's title is subject to an unapparent encumbrance, right? So we have a lot here: mortgages, easements, covenants, leases, liens, encroachments, options, and violations of a zoning ordinance, right? If any of these are encumbering the property and it's unapparent, right, we say that the seller is not delivering marketable title, right? These encumbrances make title unmarketable, right? Mortgages, easements, covenants. So we can do a few examples, right? We know easements and covenants at this point. We just got done talking about both of those, right? Imagine somebody has an easement to cross the land, right? The neighbor has an easement to use a path to cross the land, right? We know that that burdens the land. Like that easement on the land for this neighbor to cross the land, say across some path to get access to a road, well, that's an easement that burdens the land. It encumbers the property. So if that's not disclosed, right, we'd say that that title is not marketable, right? At closing, right, in order to sell that property. Now, just because you have an easement on a property doesn't mean it's impossible now to sell the property. It just means that the seller is not going to be able to deliver marketable title. So he's going to have to disclose in the land sale contract, hey, I'm delivering marketable title except for this easement I have with my neighbor, right? It just has to be disclosed. If the buyer's aware of it, okay, right? The quality of title has been specified, which is fine. But you're not, if the contract was silent as to whether or not title is marketable, we know the law requires marketable title. So if there's this easement encumbering the property, well, the seller has now failed to deliver marketable title. And we'll see that the buyer then has some remedies available. Right, so that would be an easement, a covenant. We remember the covenants. Think about a restrictive covenant. There's a restrictive covenant on the land that structures cannot exceed 15 feet in height. Right, well, that encumbers the property. That's an encumbrance, right? That if the seller delivers that without specifying, right, what the quality, without specifying that encumbrance, right, seller's not delivering marketable title. Right, any of these leases, liens, if someone's leasing out the property, that could be an encumbrance. Liens, encroachments, options, violations of a zoning ordinance, right? That would be like no structure on this neighborhood can be over 30 feet in height, and of course the house is 31 feet, right? Well, that would be encumbered. You have a direct violation of a zoning ordinance, right? It's not that there are zoning ordinances that exist. Existing zoning ordinances don't encumber the property. It's only until the ordinance is actually violated that we say it encumbers the property, which means title is not marketable. It has to actually violate the zoning ordinance. The other thing to look out for is it has to be apparent, right? The encumbrance has to be visible, basically. Or unapparent, I'm sorry. You would want it to be unapparent, not visible, right? If it's apparent or visible, right, then we say that it's not going to make title unmarketable, right? So for example, say you have an easement that's very clear to see, like power lines. Say a power line company has an easement and they have power lines going across the whole property. Well, yeah, that's an easement on the property, but it's completely visible. Anybody passing by could see those upon any type of reasonable investigation. You'd see the power lines going across the property. So that would be an easement on the land, but it's clearly visible, so we'd say title is still marketable in that case, even if it wasn't disclosed, right, at closing. Even if the seller didn't disclose, hey, the power company has this easement, right, that's fine because it's clearly visible, right? You can see the power lines going across, right? So that's just one thing you'd want to look out for. We say title is not marketable if the seller's title is subject to an unapparent encumbrance. Right, so that's what the main thing we're looking out for with title, right, and marketable title. So ultimately, what remedies are available to the buyer if the buyer learns of title defects before closing, right? Because remember, after closing, the contract merges into the deed. Now we're into analyzing the deed. The buyer's recovery would have to be based on the deed, not contract provisions, right, or the implied covenant of marketable title, right? So if the buyer, though, does learn of the defect before closing, so we're still in the contract stage, well, he can enforce the contract, right? So the buyer ultimately still, though, has to first notify the seller and allow a reasonable opportunity for the seller to cure the defects, right? So step number one is, okay, if buyer learns there's a problem, there's an easement, there's a mortgage, right, there's a covenant, whatever, there's a violation of a zoning ordinance. Step one, the buyer has to notify the seller and give the seller a reasonable opportunity to cure the defect, right? If the seller fails to deliver the required title at closing, right, seller fails to either cure the defect or fails to deliver the quality of title that was required based on what they said, right, the buyer is going to be excused from performing the contract and the seller is liable for breach of contract. So ultimately, the buyer does not have to pay the purchase price, right? The buyer's duties are going to be excused, so the buyer doesn't have to buy the home, and the buyer can sue the seller for breach of contract, seek specific performance, money damages, right? Maybe the buyer's already put down some money, some down payments. There could be other stuff, right? So the buyer could seek recovery in the form of a breach of contract because we're still in the contract stage. So that would be a breach of the implied warranty or the implied covenant of marketable title, right? Contract stage, you can sue for a breach of the implied covenant of marketable title, try to recover specific performance, damages, but also important to recognize that the contract right, the obligations of the buyer are going to be discharged, excused when we get this breach. So they're not going to have to purchase the home, right? So important to recognize, again, that it's only if the seller fails to deliver the required title at closing. So it's not that the seller always has to deliver marketable title, it's just they have to specify what the quality of the title is. So if they're silent, if the contract is silent about the quality of the title, then we know the law requires that the seller has to deliver marketable title. So if there's any encumbrances, any problems, any defects, right, then the seller is going to be in breach. But the way the seller gets out of that is just by disclosing what the quality of the title is. So if there are some encumbrances, it doesn't mean that the seller can never sell the property. It just means those have to be disclosed. The quality of title has to be disclosed. So the seller would say something like, hey, I'm delivering marketable title to the buyer except for these encumbrances, right? And then just list them out. And then if the buyer's aware of that, of course, a buyer can purchase encumbered property. He just has to be aware of it, right? So that is the idea of marketable title, right? The big picture idea is, remember, there's risk inherent in purchasing title, right? If we think about the land sale contract and the purchase of property, not as buying a house or buying a piece of land, but really buying title, buying a certificate that says you're the rightful title holder to this land, right? Well, there's a lot of risk involved in that. What if there's problems with the title? You get defective title and you just spent millions of dollars for a piece of paper that's flawed, right? Either the seller didn't own the estate he purported to be selling, or the title's encumbered, right? There's this easement you didn't know about. There's a lien you didn't know about. There's a mortgage you didn't know about. There's a violation of a zoning ordinance you didn't know about, right? All of that could cost a lot of money to resolve, right? Either by litigation or repairing yourself. So we have this idea of marketable title, right? And if the seller is silent as to the quality of title, law is going to require that the seller does deliver marketable title. Right, so that's our idea there. So the next kind of issue we get into after marketable title is other duties imposed on the seller. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.